Court does call the case of the people of the state of Michigan versus Philpott on first call case 22F11141. That's the CSC matter.
From the very first seconds of this hearing, we're thrown directly into the thick of a complicated legal situation involving DeMonte Maurice Philpott, a defendant juggling multiple cases, conflicting charges, and tense procedural questions. And notice how quickly things escalate. Right away, Judge Simpson is clarifying what exactly the court is handling today, which tells us this isn't a simple traffic matter or routine misdemeanor. We're dealing with criminal sexual conduct, weapons issues, and eventually a deep debate over search and seizure law. This case is about to explode into a full-scale legal battle. This introduction is crucial because it sets the tone for everything that follows. Watch how the attorneys speak. Very little small talk, no wasted words. That's a sign the stakes are high. When both sides come in already knowing this will be a contested case, you can expect friction, accusations, and procedural arguments at nearly every turn. And trust me, the twists ahead, especially the bodycam controversy, will leave you questioning both the officer's decision-making and the defense strategy. Keep watching, because this hearing becomes one of the most intense bind-over battles Judge Simpson has handled.
Good afternoon, Amy Reiser, appearing on behalf of the people.
Kyle Murphy, PA 379, on behalf of Mr. Philpott, who is present to my right.
All right. All right. This is going to be a waiver.
Yes,
I believe so, Your Honor. Today is the time and date set for the preliminary exam in this matter, and we are ready to proceed to preliminary exam. It's my understanding that the defendant is electing to waive his right to a preliminary exam, and the people would also waive.
All right. Sir, is that a correct statement? You understand that a preliminary examination is a proceeding where the people have to show by probable cause that the offense alleged was committed and that you committed it. You understand that you will not have that hearing on this case and that you'll proceed to circuit court for further resolution.
yes.
Preliminary examination having been waived, defendant is bound over on the single count in that case. Mr. Murphy. Circuit Court arraignment, you waive presentation and reading of the information.
Yes, Your Honor.
How does your client plead to that charge?
Like the court to enter a plea of not guilty, Your Honor.
Defendant having waived formal reading, pleading not guilty, court will enter that not guilty plea. Pretrial in this matter will be set
August 10th at 1:30 p.m. with Judge O'Brien.
This administrative moment might seem routine, but there's a deeper strategic layer here. Scheduling a pre-trial in circuit court signals that the CSC case is moving quickly, and when cases move quickly, it often means both sides have already formed strong initial positions. For the prosecution, it may reflect confidence, especially if DNA, witness statements, or digital evidence are involved. For the defense, it may indicate they want discovery from a higher court where procedural tools are stronger. But here's the real tension. While one case is smoothly advancing, the next case, the weapons and narcotics case, is about to ignite a fierce debate over officer conduct, policy, and constitutional limits. These back-to-back hearings create a contrast that's fascinating. The first case is procedural and clean. The second becomes combative and confrontational, revealing how different legal issues can shift courtroom energy instantly. This is exactly why Judge Simpson maintains such tight control. He knows what's coming, and he's already preparing to manage an increasingly volatile defense strategy.
August 10th, 2023, 1:30 before Judge O'Brien.
If I may approach this.
Yes. All right, and in this matter, bond will continue. I'm on. All right, we're ready. Court does call the case. And the people of the state of Michigan versus DeMonte Maurice Philpott. That being case 22F1-1571. Counsel, state your appearances.
Good afternoon, Your Honor. Amy Reiser on behalf of the people.
Kyle Murphy, PA 3879, on behalf of Mr. Philpott, who is present to my right.
All right, date and time set for preliminary examination. Are we ready to proceed?
We are, Your Honor.
All right.
People would call Officer Joshua Branch.
Sir, please come forward to be sworn. Guess I'll do it. No, it's okay. You can come up, face me. Please raise your right hand. Do you solemnly swear or affirm testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God? All right, have a seat. Upon having a seat, please state and spell your name for the record.
Joshua Branch, JOSHBRANCH.
All right, you may inquire.
Thank you, sir. Can you tell the court where it is that you're employed
Pittsfield Township Police Department,
and in what capacity?
police officer on the road.
The early portion of officer testimony is always groundwork, name, employment, role, but don't underestimate its purpose. By establishing Branch as a road patrol officer working on the night in question, the prosecution is solidifying his authority to make arrests, run plates, conduct checks, and initiate an impound. In Michigan, patrol officers routinely exercise broad discretion, but their training, experience level, and adherence to departmental policy become critical when evidence ends up contested. Notice something subtle. Branch is calm, respectful, almost reserved. This demeanor is important when a judge evaluates credibility. Later, when defense counsel aggressively questions him, his responses stay consistent, a trait that helps the prosecution's case significantly. But the defense knows what they're doing. Their aim is not to show Branch is lying. Their aim is to show his interpretation of policy was flawed, which could make the search unlawful even if his intentions were honest. Ask yourself, do you think an inexperienced officer should be held to the same standard as a veteran when it comes to split-second legal decisions?
And were you working in your capacity as a road patrol officer on October 19th, 2022?
I was.
And were you alone or did you have a partner?
I had a partner that
And who was that?
officer Max.
Okay. And did you have contact with the defendant in this case, DeMonte Maurice Philpott, on that date?
I did.
And what approximate time was it, if you know?
If I memory recalls, it was around 2:50.
AM, okay. And the person that you ultimately identified as DeMonte Philpott, do you see him in the courtroom today?
I did.
And could you tell Judge Simpson what he's wearing and where he's sitting?
Stipulate time.
All right, so stipulated.
And what was the nature of that contact with the defendant?
The nature of the contact was I ran a license plate vehicle that was parked inside the BP parking lot. They came back to if I'm not mistaken, Corporal Maxey had informed me that DeMonte Philpott had a felony as well out of the city township.
Okay. And what did you do with that information?
With that information, we pulled up DeMonte Philpott's photo through Secretary of State. Officer Maxey informed me stating that was him at the vehicle as well.
Okay. And did you see him in the vehicle, outside of the vehicle, if you know?
At the time I observed him, he was outside the vehicle, and as we were pulling up, he was re-entering the vehicle.
Okay. And what was the warrant for?
The warrant was for a CSC.
Criminal sexual conduct?
Yes, ma'am.
Okay. Out of your department?
Yes, ma'am.
Okay. And so what did you do then?
After that, we had approached the vehicle. We asked the person if they were DeMonte Philpott, which he identified himself as such.
Here the officer confirms the CSC warrant was valid and active in lien, meaning Branch had full legal authority to detain Philpott immediately. This is important because lawful arrest is the gateway to a lawful impound and inventory search. If the arrest is valid, the prosecution argues the chain of evidence is clean, but the defense sees it differently. Their upcoming battle hinges on why the car was impounded, not whether Philpott had a warrant. When Branch and his training officer approach, they find Philpott preparing to enter the vehicle. Officers take him into custody and immediately begin assessing the situation. Passenger without a license, private property, late-night hours, and a vehicle with no lawful driver. From a procedural standpoint, many departments default to impound in these cases. But as we'll see later, the defense argues that the impound may have been pretextual, an attempt to search the vehicle for drugs. This is where the case splits into two narratives: prosecution, lawful arrest; lawful impound, lawful inventory, admissible evidence; defense, improper impound, unlawful search, suppress all evidence. This clash is the backbone of the entire hearing.
Okay. And did you take him into custody on the valid warrant?
He did.
And what happened next?
After that, we identified the other passenger inside the vehicle. They also do not have a license and conducted an inventory search of the vehicle prior to impound.
Okay. And I should apologize. Let me back up. I asked if the CSC warrant was valid. Was it in lien?
Yes,
Okay. And you said the passenger did not have a driver's license?
correct.
And did Mr. Philpott have a driver's license?
I do not recall this.
Okay. So you then did what? You said impounded the vehicle?
I performed an inventory search prior to the impound.
Okay. And what, if anything, did you locate during that inventory search?
I located a firearm on the driver's seat of the vehicle, along with suspected narcotics in the door of the driver's door.
Okay. And did you say there was a passenger in the passenger seat? Anybody in the rear of the vehicle?
Nobody in the rear of the passenger
And where was Mr. Philpott when you took him into custody?
driver's seat.
And I'm going to show you, did you take the weapon into custody?
I did take proper possession of the weapon.
What kind of weapon was it?
It was a handgun.
What kind of handgun?
Single stack from my recollection.
And the suspected narcotics, were those also taken into custody? Okay. And were they tested? And did they test positive for cocaine?
The officer now confirms a fully formed triad of incriminating evidence: a handgun, ammunition, cocaine that tested positive through a field narcotics test. From a prosecution standpoint, this is devastating. The combination of drugs, scales, and a loaded firearm often leads prosecutors to argue intent, not mere possession. Even though this is just a preliminary exam, probable cause becomes easy to establish with these items present. Branch's testimony also reinforces the idea that the evidence collection was methodical and properly documented. He identifies photographs, confirms the items, and verifies that testing occurred in his presence. For Judge Simpson, known for valuing procedural structure, this level of documentation strengthens the prosecution's narrative. But for the defense, this is where strategy becomes narrow and intense. They cannot argue the items weren't there. They cannot argue Philpott wasn't present. Their only possible lifeline is undermining the legality of the search itself. If the impound is found improper, everything discovered afterward collapses.
Courtroom actually did one of the tested positive. Yes.
Okay. With a true narc test?
Yes.
And did he do that in front of you?
Yes.
Okay. I'm going to show you what's been marked as People's Proposed Exhibit 1 and 2 and ask if you recognize these photographs.
I do.
And can you tell the court and for the record in People's Proposed Exhibit 1, what are those photographs of?
Photographs of the vehicle, 2 photos, one from the driver's side, rear portion of the vehicle, one of the front driver's seat, 1 photo of 3 scales that were recovered, and 1 of the suspected narcotics at the time.
Okay. And are those a fair and accurate representation of how those items appeared on the night of October 19th, 2022, or early morning hours?
Yes.
Okay. And in Exhibit 2?
Exhibit 2 is a black handgun firearm. The specifics is going to be an FN 503.
Okay. And was that loaded?
Yes, that was one of the chamber.
I would move for the admission of Exhibit 3.
The prosecution is building a clean evidentiary foundation, admitting photographs and documentation that strengthen their chain of custody. This is a procedural moment, yet it carries immense value for what's coming. Once evidence is admitted, even just for purposes of prelim, it signals that the judge accepts its relevance and authenticity. Defense attorneys know this is dangerous because the more evidence becomes part of the record, the harder it becomes to suppress later. What's important to understand is that judges don't need perfect evidence at this stage. They only need enough to justify moving the case to circuit court. Still, Judge Simpson is not passive. He watches closely whether the prosecution is following proper procedure. The admission of exhibits is a sign the state is doing its job by the book. But here's the twist. The defense is quietly preparing to challenge not the exhibits, but the foundation beneath them, the decision to impound. It's like seeing a chess player sacrifice small pieces while setting up a devastating endgame attack. Viewer question: if the evidence itself is strong, should a judge still throw it out if police made a procedural mistake earlier? Why or why not?
Any objection or voir dire?
No objection for the purposes of preliminary exam.
Exhibit 3 is admitted.
And did you run Mr. Philpott's criminal history
I did.
and determine that he was ineligible to possess that firearm?
Yes.
I'm going to show you what's been marked as Exhibits 3, 4, and 5 and ask if you can identify those for the record.
Have one. That's what I thought. Ms. Reiser, you said you asked for the admission of exhibit 3, and I thought I had lost track and was going to cut with my recorder, but you meant exhibits 1 and 2.
I meant exhibit 1 and 2.
Yes, okay, so exhibits 1 and 2 are admitted. I have not yet admitted
And I'm showing him proposed 3, 4, and 5.
5. Got it.
And do you recognize exhibits 3, 4, and 5 to be certified convictions of Mr. Philpott?
I do.
I would move for the admission of exhibits 3, 4, and 5.
Any objection of what is
For the purpose of preliminary examination.
exhibits 3, 4, and 5 are admitted.
And I'm going to show you people's proposed exhibit 6. I labeled this number 7. I don't know where 6 is.
Okay.
I'm going to
It's
approach
okay.
and show you 7 and ask
7.
if you recognize this. There is no 6. That were recovered from the driver's side of the vehicle?
Yes.
Did you remove the ammunition from the chamber and make the gun safe?
I did.
Okay. Thank you. I don't have any other questions. The location where you, I do have another question. The location where you had contact with the defendant at 2:50 a.m. on October 19th, 2022, is that located within Pittsfield Township, Washtenaw County?
It is.
You said it was the BP gas station?
Yes.
What's the address?
I do not recall.
Is that at Washtenaw Avenue and Gulfside?
The officer's testimony now moves into procedural detail, how he made the weapon safe, where the arrest took place, and confirming the jurisdiction. These may seem like minor points, but in legal terms, they're essential building blocks. Every piece of this testimony ensures the prosecution can defend its case against technical objections. If an officer mishandles a firearm or misidentifies a location, it can sometimes become grounds for challenging evidence. But more importantly, this is the calm before the storm. Once jurisdiction is confirmed, the defense shifts sharply into confrontation mode. They begin challenging the officer not on what he found, but why he encroached on the vehicle in the first place. This is where the BP location becomes critical. It's private property. Vehicles are often allowed to remain parked there temporarily. The defense believes no policy mandated impound. This location becomes the battleground over whether the officer acted out of necessity or out of suspicion. And that distinction will determine the future of the entire case.
Okay. Thank you. I don't have any other questions.
And so we're clear, it's on the west side of Gulfside, which is Pittsfield Township. The court can take judicial notice of that.
Okay. Thank you.
Did you wish exhibit 7 admitted?
Yes, please.
Okay, no objection. Exhibit 7 is it? Exhibit 7 is admitted. Cross-examination.
Officer Branch, you talked about making a decision to impound the defendant's vehicle. Why did you do that?
What's that?
Why did you choose to impound it?
I was informed by my training officer at the time that the vehicle,
Do you know why?
based on policy, and some other things.
Is that what he told you that day?
I'm not mistaken.
Your testimony here today is that he told you that you were going to impound it based on a policy?
From my understanding, it was by policy.
That night, did you tell Mr. Philpott that you were not going to impound the car before later changing your mind?
This is the turning point. The defense begins attacking the intent behind the impound. They question whether the officer told Philpott the car would not be impounded, then changed his mind later. This line of questioning is not about courtesy. It's about establishing inconsistency, which can be used to argue pretext. If the officer said the vehicle wouldn't be impounded but later reversed course, the defense can argue that the change wasn't based on policy, it was based on a desire to search the vehicle. That would violate Fourth Amendment protections unless specific criteria were met. Defense counsel's approach here reveals their strategy. Suggest the officer lacked clarity. Suggest he lacked authority. Suggest he changed his mind based on influence or improper motivation. Use that to undermine the entire impound decision. This is where Judge Simpson begins reacting. He has zero patience for arguments that twist facts or rely on speculation. Watch how quickly he becomes protective of the record when he believes the defense is reaching too far.
What I told him, if my memory recalls correctly, I told him that I would not get my own driver.
And when you told him that you weren't going to impound it, were you telling him the truth?
From my proposed view at the time, yeah.
Yeah, that's all I'm asking at the time. Very good. Time of Well, before you decided to impound the vehicle, did you enter the BP gas station?
We did.
You entered the inside, the convenience store, for lack of a better description?
No, not the convenience portion, no.
Did you speak to the clerk inside the gas station?
No,
Are you aware that any other officer spoke to the clerk inside the gas station?
I am not aware,
Are you aware of whether or not the clerk came outside of the gas station?
no.
Surprise you to find out that there was body camera footage of Officer Maxey suggesting that you impound the vehicle in order to search for drugs?
Here is where the courtroom temperature spikes. The defense insinuates that Officer Maxey, the field training officer, told Branch to impound the vehicle specifically to search for drugs. This is a dangerous accusation because it implies intentional misuse of police authority. If proven, it could collapse the prosecution's entire case. But Judge Simpson reacts immediately. He stops the exchange, reminding defense counsel that multiple hearings have already examined this issue and that the video has been thoroughly reviewed. His irritation is clear. He believes the defense is trying to mischaracterize the content of the body cam footage. Simpson's tone shifts from neutral to stern, signaling that he views the defense's framing as misleading. This marks one of the most dramatic moments in the hearing. Simpson essentially accuses the defense of manipulating the narrative, which is rare for a judge to say so directly. It sets the tone for a courtroom where patience is gone, the stakes are high, and factual accuracy is non-negotiable. The moment forces a crucial question. Was the suggestion to impound truly a training scenario, or was it a tactic to justify a search?
Okay.
I'm gonna open that.
I think we need to stop right this second because I had 3 or 4 hearings on this, counsel.
Yes.
And I'll allow any attorney to ask what questions they want to ask. But there certainly is video of it. This court specifically looked at that video. You did the same thing during that hearing in suggesting or really informing the court initially, prior to receiving the whole video, that this officer said that he was going to impound it, and that the other officer changed his mind. When point of fact, that's not what happened at all.
Respectfully, Your Honor, I disagree.
No, you can respectfully disagree. Play the video. Let's play the video because the video is clear. This officer was in training. The questions were specifically asked of this officer. He makes an assessment. His field training officer says, think about this, and this. The whole scenario that they're going through is a field training officer training another officer. It's not the suggestion and this other stuff. I'm not going to let you pollute the record with things that are just wrong. So if you want to play the video, counsel, play the video.
I'd like to
But
play the video, Your Honor.
play it now then.
This is one of the most explosive exchanges in the entire hearing. Judge Simpson is no longer just presiding. He is policing the accuracy of the narrative. When he tells defense counsel they attempted to mislead the court, that is a severe judicial reprimand. This indicates that Simpson believes the attorney is stretching or distorting the sequence of events regarding the impound. For viewers, this underscores a powerful courtroom reality. In a prelim, credibility matters just as much as evidence. The judge insisting, "Play the video now," shows he wants the record to be clean, unambiguous, and free of reinterpretation. Simpson's tone conveys frustration. He has already reviewed this footage in earlier hearings, and he is not willing to let selective framing influence the legal conclusions. This moment also highlights how bodycam footage has become a decisive factor in modern courtrooms. The judge leans heavily on it to cut through verbal disputes, ensuring that factual interpretation stays grounded in visual reality.
Play it now and then ask the questions. Because you attempted to try to mislead the court before. Play the video and then ask your questions.
Counselor. Judge, I believe it was Miss Kirby who played the video at our last hearing. And for that reason, I have not hooked up to this particular system. And I wonder if that maybe.
All you need is a
Let's
cord
jump.
and a player on your computer. You can hook right into the system. It's not a problem. Listen,
Very good, Judge. Your Honor, I do have 2 additional questions before we
go for
play
it,
the video.
as long as they're fair.
Officer, how long have you been employed by Pittsfield Township?
By Pittsfield since last August.
Was that your first job as a police officer?
No,
Where else did you work?
Detroit.
How long did you work there?
3.5 years ago.
Did you work anywhere else before that? Okay. So how long have you been a police officer in total?
At this time, it's coming up to a little around 4.5 years.
4.5 years. Did you undergo training as a Detroit police officer? Did you complete the MCOLS program before becoming an officer? And did you were you undergoing training at the time of this arrest?
Defense counsel now shifts strategy. Instead of arguing the impound directly, they attempt to erode the officer's experience and judgment. They emphasize that Branch was relatively new, still undergoing training, and had only moderate prior experience at other departments. This approach is deliberate. If the officer can be portrayed as inexperienced, the defense can later argue that he relied excessively on his field training officer and did not independently apply department policy. In Fourth Amendment arguments, this matters because the legality of the search hinges on whether the officer made a reasonable decision, not merely whether he followed instructions. But Branch's responses remain calm and consistent. He acknowledges his training stage but reinforces that he had undergone the required certification. For Judge Simpson, this helps dispel any notion that Branch acted recklessly or without authority. The defense is planting seeds for a potential suppression motion in circuit court, but Simpson is making it clear he won't entertain speculative arguments at prelim. Viewer question: should less experienced officers be given more leeway for mistakes, or should all officers be held to the same constitutional standard regardless of tenure?
Very good. Your Honor, can we take a brief recess while we try to figure out how to play this video?
We're to stand in recess.
Thank you.
All right. Where are we? We're ready to play
I do have the video worked out. Sister counsel here was kind enough to load it up so that it can be played on the court's monitors. With the court's permission, I would like to play that video unabated for at least the first 10 minutes, but as long into the video as Your Honor would.
Well, whatever you need.
Just for the record, Judge, it's 46 minutes in total.
Oh, I know. I watched the whole video before.
Willing to watch it with you, Judge.
Well, I already watched it once. It's like a rerun. But however much of it you think you need to play, I'm just saying that the real interaction occurs, and I don't know the timing, but when actually there are the 3 folks there and the field training officer is talking to this officer. So whatever point that's at, you can back up a little bit from that, but run it through because you see the context upon which all of these statements are being made.
Okay, so for the record, I'm playing Pittsfield Township 22-13689. This will be the body cam of Officer Tyler Maxey.
All right.
Or maybe
You got it. You got it?
Mhm.
Okay. Thank you, man. Yeah, your laptop controls volume. So a little down, a little lower.
For assault. Demonte Philpott, correct? Yes. Okay. Yeah. Actually, last contact you or you can call me. Okay, we'll look it up in the car, we'll show you. Who's passenger? That's one girl. Okay. Who's client? Okay. Does she have a driver's license? Okay, that's good. Alright, my guy's gonna check you and he's gonna have a seat and I'm gonna talk to her and see if she can drive the car, okay? I'll let them know. So, he has a warrant for his arrest. I'm gonna go to Washington County Jail. Do you have a driver's license to drive the car? Okay. I'm just trying to figure out what we're gonna do with the car. So, that's the thing.
I have a I take my license personally. And I already got 10 and 50 from years ago.
Okay, so you have that, yeah.
Bless you.
I mean, I figure out what's going on here, but I don't know. So. Just, hold on for now. So felony for sex assault on Pittsfield, they put in July of this year. She said she was not. No, that's not that. So what do we need to do now? So what do we need to do? Dispatch on the attic and then. Yeah. But I dispatch needs to know. Never, we have, and that they need to confirm. They need to tell us whether or not the jail's going forward. That's in there. And I know I talked about the guy away a couple weeks ago, and he told me that he's been looking for him, but he was in school now. So.
This large section of video playback is the heart of the legal dispute. The footage shows the field training officer, Maxie, walking Branch through options, procedures, and considerations. The dialogue is instructional, not conspiratorial. Maxie is clearly training, not manipulating. This destroys the defense's earlier implication that the FTO intentionally pushed for an impound to search for drugs. Instead, the footage supports the prosecution's argument. Officers were weighing logistical and policy-driven options. The passenger lacked a license, the vehicle was on private property, and leaving it unattended could create liability issues. What the viewers must understand here is how police discretion works. Training officers often ask questions like, "What would you do?" Not to direct outcomes, but to test judgment. That's precisely what the video shows. This makes the defense's insinuation appear weaker. In fact, the footage strengthens the prosecution's position by showing that the impound came from an evolving assessment, not a predetermined plan to search. Ask yourself, if a field training officer presents options, is that improper influence or normal supervision?
Okay. We'll confirm that your warrant is valid, but it's not valid. So just checking here. CSC more bus. So there's two options that we can do. We can either try to allow license what we can do. I understand, but either me or make what. Yes. That way, if there's anything in there. So he's gonna go to we're gonna check first, that way if officer allowed to like find something in the car that belongs to you. If you're sitting with a gun, we can deal with that, but if it's just a taco. So yeah, we can have this investigation. But he does have one. That way. So because there was a article in the detain, that's doesn't mean you're going to jail. But just because there was that pistol in the car, we're gonna have to do a little more investigating, and just made me feel uncomfortable if you're in handcuffs and could have done otherwise. Do you have anything on your complaints? You know, are you okay with me just going straight up? I mean, Receipt.
Yeah.
Okay.
Your Honor, if the court's satisfied.
I am. I'm satisfied. I mean, wherever you want to stop it, I'm good.
Mr. Counsel, I think we're ready for a moment.
All right, you may continue your question.
Officer Branch, was it your testimony earlier that you impounded the car pursuant to a policy?
Yeah.
Do you know what that policy is?
Off the top of my head right now.
Okay. Would you give me a recollection at the time of what you believe the policy was?
At the time, from my recollection, it was impound the vehicle when I block businesses, transactions, or if it's illegal at the time.
And that was your understanding at the time? Okay. Were you able to hear what was said in the video?
Hardly, but yes.
Okay. If it's necessary, I don't mind going back to the pertinent points. So please let me know if that's necessary. Okay. Were you able to hear yourself say, or did you say to the defendant that there were two options on what to do with the vehicle before you made the decision to impound? Do you recall what those two options were?
Defense counsel now tries to crystallize the impound issue. Was Branch following written policy or simply deferring to his trainer? This line of questioning is important because if the impound violated department policy, the defense could argue the search was unlawful, but Branch struggles to quote the policy verbatim, something very common among officers and not legally damning by itself. Most officers follow training and standard practice rather than memorizing policy language word for word. Judge Simpson knows this, which is why he doesn't give this attack much weight. The officer also recalls offering the defendant two options before the impound: letting someone else drive the vehicle or leaving it parked. Only after those failed did the FTO introduce impound as the third choice. This shows a progression of reasoning rather than a hidden motive. For Simpson, this reinforces probable cause and undercuts the defense's claim of a pretextual search.
They want to find someone to drive the vehicle, and the other passenger was not licensed, or we would impound the vehicle.
Can we go back and play that portion of the video, please? It's going to be.
Am I just hearing the same motion again?
Your Honor, I'm trying to get the testimony from the gentleman here.
I understand what you're doing. I'm asking you a question that you'll answer. Am I just hearing your motion again?
No, Your Honor, I don't intend to make the same motion again.
Well, you're going to have to speed this along because I mean, this sounds, it sounds like the same thing. If you want to raise your Fourth Amendment argument in circuit court, you may do so. But my issue here is going to be whether or not there's probable cause to believe that a crime was committed and whether or not this defendant did that. That's the only thing I'm here to decide right at this point in time. And it seems like you're just going through your motion, which I've already denied after 6 appearances before.
Your Honor, I'm just trying to make sure that we have testimony of what.
Which could have been done with the motion, which is why everybody was here. And so that's what I'm asking. Am I just hearing the motion?
No, Your Honor. At the time, we had stipulation from the people as to what was said. We're asking now to try to discern the intent of the officer at the time, which we can't get alone from that stipulation.
But intent is not an issue I decide at this stage, counsel, is what I'm getting at.
No, Your
If
Honor.
it comes down that it's a question of intent, it gets bound over because that's a question of fact for the jury. It wouldn't be something I could decide. So why am I here is what I'm asking. If that's the issue, the intent of what this officer did, then we might as well just stop this now because I can't decide that. You should know that.
Yes, Your Honor, but the testimony is still necessary for us. If we choose to make the motion based on what Officer Branch says, we choose to renew that motion based on what he says later in circuit court.
Then you'll have the opportunity during the motion. I mean, play it again. I guess we'll just be here all night listening to the same thing over and over.
So there's two options that we can do. You can either try to comply with that. So don't have a license for one parking. You can try to get around.
Thank you so much.
I asked you for what, if you recall, the two options that you gave. I just replayed the video where I believe you were making those statements, correct? Do you recall what those two options were?
I can hear it a little clearer now, but the other option was to park the vehicle.
Could you state what both of them are?
Yeah, the first option was to find another driver, since the passenger was not licensed, or to park the vehicle.
Thank you. And at some point, did you decide to impound the vehicle?
After counsel with my active.
Were you able to hear on the video? Do you recall what your training officer said to you that caused you to create a third option or to defer from the two options that you said?
Sustained.
I'll rephrase.
Sustained.
I'll rephrase, Your Honor. You hear Officer Maxey suggest that you impound the vehicle.
Yes.
Did you hear the words that surrounded that?
Based on prior history. Yes.
Are you saying that you can infer what he said based on your prior history with him? I'm not sure I understand your answer.
No, I can hear based on prior history of narcotic trafficking.
Okay. And is that the statement that caused you to decide to impound the vehicle?
No.
Why did you change your mind?
This moment reveals the defense's last attempt to salvage the suppression argument. They want Branch to admit he changed his mind solely because Officer Maxey suggested impound. If Branch had admitted this, the defense could argue he wasn't exercising independent judgment, but Branch resists that framing, clarifying that his decision came from a combination of factors: training, situational assessment, policy considerations, and trust in the process. His answer diffuses the defense strategy. Judge Simpson recognizes immediately what the defense is trying to do: blur the line between guidance and coercion. He has already made clear he believes the defense is overstating the influence of the training officer. Once again, Simpson's irritation resurfaces, though he maintains control. The judge is signaling that he sees no foundation for suppression within the testimony being elicited. This cements the prosecution's advantage. The impound appears lawful, the search proper, and the evidence admissible, devastating for the defense. If an officer trusts his trainer's judgment, should that invalidate his own decision-making?
I'm going to ask the FTO must be based on his training and experience, on what I should be doing in that case.
What other training and experience did he give you from the time you made those suggestions to the time you decided to impound, other than the statement we just addressed?
The statement alone is not necessarily what made me change my mind. It's my trust in my active.
Okay. How long have you been training with Officer Maxey?
I've trained with Corporal Maxey, I believe only that day.
Did you do what you were told?
Yes.
Did Officer Maxey ever ask you to do things that you refused to do?
No.
Did he ever suggest to you conduct in order to test you?
Not that.
Did he ever ask you to do things or suggest that you take a course of action that you knew to be unlawful?
Not once.
Very good. No further questions, Your Honor.
Any redirect?
Briefly. Officer Branch, Corporal Maxey was training you?
Yes.
It appeared in that video, he was showing you how to use what's that computer system called in the car?
The computer system part is the lead system.
And was he showing you how to use that?
No, he was advising me on something that's done with Pittsfield that was not done with my previous department.
Okay, so some different policies and procedures.
Correct.
Okay. And did he sit with you in the car and confirm that the defendant had a valid warrant
Yes.
before taking the next step of action?
Yes.
Okay. And Officer Maxey spoke with the passenger and determined she did not have a valid driver's license.
Correct.
Okay. And so it sounded like in that video, he said, "What would you do?" Is that correct? And you indicated she doesn't have a driver's license, so we can't let her take the car.
Correct.
And your second thought or option was to leave the car parked.
Yes.
Okay, and there was a third option suggested to you by your FTO.
Correct.
Okay. And in terms of leaving the car parked, could you leave it parked in a private facility, in a private business?
It was legally part of the authorization of the employees there. Yes.
Okay. And what about your policy at Pittsfield? Were you aware of that?
I was aware of a majority of the policy at the time. From my recollection now, and that is going to be slightly.
Okay, so you have to have permission from your command to leave a vehicle parked on private property. And did you have that? Okay. And the impound was done incident to the arrest of the defendant
Correct.
after you confirmed his valid warrant. Is that correct?
Correct.
Okay. And then the vehicle was impounded
Yes.
and you inventoried it.
Yes.
Is that pursuant to policy?
Yes.
Okay. And what, if anything, did you locate during that impound?
I located a firearm or handgun along with a suspended cut.
Thank you. I don't have any other questions.
Just have one brief follow-up, Your Honor.
Sure.
Officer Branch, I appreciate this. Would you just clarify something? I asked you about whether or not anyone went into the BP gas station, you, other officers, whether you're aware of it. I believe it was your testimony just now that you weren't aware that the vehicle had permission to be at that private property.
Correct.
Did you have any reason to believe that it didn't?
Where it was parked at the time.
I'm sorry?
Parked at the time, the vehicle did not stay there.
Why?
Pump which in place.
Did you, I'm sorry, I thought it was your testimony that nobody went into the BP gas station, nobody came out of the BP gas station. So I'm unclear on what you mean by that.
So reject on relevancy grounds, whether anyone went into the BP gas station or came out of it. I'm sure there was a lot of business then.
Respond
Yeah, I believe it is relevant.
to what?
Well, the people are trying to make the argument that the impound was proper in part because the vehicle was hampering private property. And I'm trying to make it clear that.
Hold it, hold it.
Just following on the.
That's why this is like Groundhog Day. I went through this already with the motion. And you were given, counsel, 2, if not 3 opportunities because you had alleged or made the representation to the court that someone there said the vehicle could stay. And I gave you an opportunity to bring that person before the court. One time you brought what looked like, I guess, an attempt at an affidavit. And the question I had was, that's not the owner. And then we adjourned again because you were going to go get the owner.
Yes, Your Honor.
And then you came back, guess what? No owner.
Yes,
Nobody came down. Nobody said anything.
This is where Judge Simpson draws a hard line. Defense counsel insists on revisiting whether anyone from the BP gas station granted permission for the car to remain. Simpson immediately rejects this as irrelevant unless proven by testimony from the actual property owner, which the defense repeatedly failed to produce. He reminds them sharply, "You had multiple chances. You promised to bring the property owner. You did not. Stop relitigating settled issues. This is judicial authority at its peak." Simpson is maintaining the integrity of the proceeding by preventing defense counsel from recycling arguments without evidence. For viewers, it's a lesson in courtroom discipline. Judges will entertain arguments but not repetitions, speculations, or undone homework. This exchange also reveals Simpson's awareness of how defense tactics can muddy the record. Instead of allowing confusion, he forces clarity.
And now you want to argue it here again.
No, Your Honor. I'm trying to get testimony about whether or not they were told that there was no permission to remain there, or whether they decided it for themselves. I'm satisfied with the answers Officer Branch has given. They answer that question.
Are we done then?
Yes, Your Honor.
Anything else, Ms. Reiser, from this
No,
witness?
Your Honor.
You may step down. Thank you, MC. Any other witnesses for the people?
No.
No?
No, I don't have any other witnesses, John. I would make an amendment to count 2 and count 3 with the additional convictions that have been mentioned, the controlled substance delivery, manufactured less than 50 grams, and the police officer plea in lieu. I would just add those both to the felon in possession of a firearm and the ammunition.
Gotcha. Any objection to that?
No, Your Honor.
Any witnesses for the defense?
No, Your Honor.
Motion?
People would move for bind over on count 1 through 4 contained within the felony information. I believe that the testimony of Officer Branch is sufficient to make a probable cause finding that the defendant did carry a dangerous weapon, to wit, a handgun, whether concealed or though otherwise in a vehicle operated or occupied by the defendant, the Ford vehicle that was shown in the video. And 2, that he is a firearm possession by felon, that he did possess, transport, or carry a firearm while ineligible to do so because he or she had been convicted of possession of cocaine or other narcotic, controlled substance delivery, manufactured less than 50 grams, and or police officer fleeing in a low third degree. And count 3, that he did possess, transport, and carry ammunition when ineligible to do so, based on the officer's testimony that it was loaded with one in the chamber, that he was ineligible also to possess, transport, or carry the ammunition because he had been convicted of the 3 listed felony convictions in Exhibit 3, 4, and 5, and that he did knowingly or intentionally possess less than 25 grams of a mixture containing the controlled substance cocaine.
Response.
Your Honor, just for the record, we renew our motion that evidence in this case should be suppressed.
How do you do that? How? Give me your argument then. I mean, I don't even know how you're raising that motion again. I'm at the preliminary examination. You already have raised the motion. You then supplemented the motion.
Yes, Your Honor.
I mean, if you want me to go through the entire record that I've been through this case, and now you're renewing that motion again at the district court stage at exam?
Yes, Your Honor.
When give me your authority for doing that, counsel, because you're playing by a different set of rules that don't apply. Give me your authority to raise it at this proceeding. Right now. Right now. If you need to take a break to find the rule, you find the rule. Otherwise, yep, you take your break, find the rule. Court will stand in recess. You can go ahead. You're not going to find it in here staring at me. Please, for God's sakes, take me off the record. Yep, just start it. My polycop's on. My create video is on, and I'm live. All right, we're back on the record in the case of the People versus DeMonte Philpott.
Kyle Murphy, PA 3879, on behalf of the defendant, Mr. Philpott.
Amy Reiser, again, on behalf of the people, Your Honor.
Your Honor, the court had asked for authority in which to make a motion or renew a motion to suppress evidence.
At preliminary exam.
Yes, Your Honor. And all I can point the court to is 6.508, particularly B, which allows the court to make a decision that would otherwise require an evidentiary hearing on its own. And it does specifically list, quote, the expanded record. In this case, Your Honor, the record Although the court may not be satisfied in the way the record was expanded, we do have an expanded record today based on Officer Branch's testimony. For that reason, I'd like the court to consider Officer Branch's testimony.
Okay, I will consider Officer Branch's testimony with regard to the motion to suppress, which was previously raised. Taking that into consideration with the entirety of the other circumstances in which the motion were raised and the evidence received and an argument received at that time, the motion to suppress is again denied.
Thank you.
And you're,
Anything else?
no, just making my motion for bind over.
All right. Anything else in response?
No, Judge.
Court has heard the testimony in this case, and with reference to counts 1, amended count 2, amended count 3, and count 4, the court would rule that the people have indeed sustained their burden of showing that the defendant committed these offenses and that these offenses were committed and that this defendant committed those offenses. Therefore, the defendant is bound over to stand trial on all 4 counts. Counsel, as to the circuit court arraignment, do you waive presentation of the information and its reading?
Yes, Your Honor.
And how does your client plead?
I'd like the court to enter a plea of not guilty at this time.
Defendant waiving presentation and reading of the information. Court will enter a not guilty plea as to all 4 counts. Pretrial in this matter will be set for
August 10th at 1:30 PM with Judge O'Brien.
August 10th, 2023, 1:30 before Judge O'Brien.
Thank you, Your Honor. And if there's no objection from counsel, I'll file a new information with the amendments to counts 2 and 3 prior to the pretrial.
Very good.
No objections.
Thank you.
And then for the court record, there should be an order denying his motion to suppress dated 6/8/23 and then another order dated 7/6/23.
Yes.
Did you do the one from 6/8 also?
The one from 6/8 has been entered. If your office doesn't have a copy, it was signed here in the courtroom.
Yes.
Do you want another one from today?
Yes.
I'll send another one over from today. 9.
I can, yes. I believe your front office staff may be gone today at this point, so we'll have to.
We'll be here tomorrow.
Exactly.
Thank you. That it for us, man. Thank you very much. 14A is adjourned.
The hearing closes with decisive rulings. Judge Simpson denies the renewed motion to suppress, binds the defendant over on all 4 counts, and schedules the pretrial in circuit court. This marks a complete victory for the prosecution at the preliminary stage. The judge found the officer credible, the impound justified, the search lawful, and the evidence strong enough to move forward. For viewers, the case illustrates a critical truth about criminal hearings. A preliminary exam isn't about winning the trial, it's about survival. And today, the prosecution's case survives intact. The defense attempted to challenge intent, policy, procedure, and interpretation of video evidence, but none of it undermined the probable cause required to advance the charges. In the broader legal landscape, this case highlights the ongoing debate over vehicle impounds, officer discretion, and the boundaries of Fourth Amendment protections. It also demonstrates how bodycam footage now plays a defining role in shaping courtroom narratives. If you found this case as shocking and intense as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.